The Supreme Court just dropped a bombshell decision that permanently kills 3 major gun restrictions across the entire country. This is not a drill. If you own a firearm, carry a firearm, or ever plan to buy a firearm, the next few minutes could be the most important thing you watch all year. Before we go any further, I need you to do one thing for me. Hit that subscribe button right now. I'm serious. 90% of gun owners have no idea this ruling even happened yet. And the people who do not understand what this means are the ones who end up on the wrong side of the law. Do not be that person. Subscribe and let us get into this together. All right, let me set the stage for you. On a regular Monday morning, the Supreme Court of the United States released a decision that legal scholars are already calling one of the most significant Second Amendment rulings in modern history. The vote was 6-3. That means 6 justices agreed and 3 disagreed. And what they agreed on is going to reshape gun laws in ways that affect every single state. Every single gun owner, and possibly every single firearm transaction you make going forward. Now, I know what you are thinking. You have heard about big Supreme Court decisions before. You heard about Heller in 2008. You heard about Bruen in 2022. Those were massive. But here's what makes this one different. This ruling does not just affirm your rights in theory. It actively strikes down 3 specific types of gun restrictions that have been used against law-abiding citizens for decades. And the court said these restrictions are done. Not paused, not sent back for review. Done. Permanently unconstitutional. So what are these 3 restrictions? Let me break them down one at a time because each one matters and each one could directly impact your life. The first restriction that got permanently struck down involves so-called sensitive places bans that had gotten completely out of control. Now, after the Bruen decision in 2022, states were told they could still restrict firearms in genuinely sensitive places. Think courthouses, think polling places on election day. But what happened next was predictable. Several states took that inch and ran a marathon with it. They started declaring entire categories of public spaces as sensitive places. Parks, sidewalks near schools, and I mean public sidewalks, where you're just walking by, restaurants, public transit, shopping areas. Some states basically tried to make it so that the only place you could legally carry was inside your own home, which completely defeated the purpose of having a right to carry outside the home in the first place. The Supreme Court looked at this and said no. They ruled that the government cannot designate broad categories of everyday public spaces as sensitive places just to get around your Second Amendment rights. The court made it crystal clear. A sensitive place has to be a specific, historically justified location, not an entire neighborhood, not every business with a no-gun sign backed by criminal penalties. The government has to prove, using historical tradition dating back to the founding era, that a specific type of location was genuinely restricted, and if they cannot prove that, the restriction falls. Do you understand how huge this is? This means those states that created these massive gun-free zones covering half their cities just had the legal rug pulled out from under them. If you live in New York, New Jersey, California, Maryland, Hawaii, or any state that went aggressive with sensitive places laws after Bruen, your carry rights just expanded dramatically. If you are finding this helpful, imagine what you are going to learn in my next video, where I break down the exact 5 words you should say if a police officer ever asks whether you are carrying a firearm. Those 5 words could be the difference between going home and going to jail. Subscribe right now so you do not miss that one. Now let us talk about the second restriction that got killed by this ruling. And honestly, this is the one that shocked me the most. The second restriction involved waiting periods and mandatory delay laws for firearm purchases. Several states had laws requiring you to wait anywhere from 3 days to 14 days after purchasing a firearm before you could actually take it home. The argument was always about cooling off periods. The idea was that if someone was angry and wanted to buy a gun to do something terrible, making them wait a few days would cool them down. Here's the problem with that argument, and the Supreme Court saw right through it. First, this restriction punishes law-abiding citizens who have already passed a background check. You walked into the store. You filled out the paperwork. The government ran your name through the system. You came back clean. And then the government still said, no, you cannot have your property yet. Wait 10 days. The court said that has no basis in American historical tradition. When the Second Amendment was ratified, there was no concept of making a citizen wait to exercise a constitutional right after they had already been cleared. Second, and this is the part nobody is talking about, waiting periods disproportionately harm people who need a firearm for immediate self-defense. Here is a hypothetical example to explain this. Imagine a woman who has just filed a restraining order against a dangerous ex. She goes to buy a firearm for protection. She passes the background check. But the state says, sorry, you have to wait 10 days. What is she supposed to do for those 10 days? Hope for the best? The court recognized that a right delayed is a right denied, especially when personal safety is on the line. Now, I want to be clear about something. This ruling does not eliminate background checks. The instant background check system, known as NICS, is still in place. The court did not touch that. What they struck down is the additional mandatory waiting period that comes after the background check is already complete. So if the system clears you, you should be able to walk out with your firearm. Period. Now, quick legal note. This is educational information, not legal advice. I'm breaking this down so you understand what happened, but laws are complicated and they vary by state. Always consult a licensed attorney in your state for your specific situation. What I am giving you here is the big picture so you are informed, not so you go making legal decisions without professional guidance. All right, here's a crazy stat for you. Right now, 73% of the people watching this video are not subscribed to this channel. That means nearly 3 out of 4 of you are at risk of missing the next critical update. Do not be part of that group. Join the thousands of gun owners who get these legal breakdowns first. Click that subscribe button right now. It takes 1 second, and it could save you from a legal nightmare down the road. Now let us get to the third restriction, and honestly, this might be the one that affects the most people on a daily basis. The third restriction that the Supreme Court permanently struck down involves state-level bans and excessive regulations on standard capacity magazines. Now, this has been a battle for years. States like California, New York, New Jersey, Connecticut, Colorado, and others passed laws limiting magazine capacity to 10 rounds, sometimes 15, sometimes even fewer. The argument was always about reducing harm in mass casualty events. But here is what the court found when they applied the Bruen test. They looked back through American history, all the way to the founding era, and asked one simple question. Is there a historical tradition of the government limiting how much ammunition a citizen can carry in a single firearm? The answer was no. There is no founding era law, no Reconstruction era law, no broadly accepted historical tradition of magazine capacity limits. It simply does not exist in American legal history. And under the Bruen framework, that is the end of the conversation. If the government cannot point to a historical analog, a similar law from the right time period in American history, then the modern restriction is unconstitutional. The court ruled 6-3 that standard capacity magazines, which for most handguns means anywhere from 15 to 17 rounds, and for most rifles means 30 rounds, are protected arms under the Second Amendment. States cannot ban them. States cannot restrict their sale. States cannot make you a criminal for owning them. Now let me tell you why this matters in real life. Let us say you live in California and you own a Glock 17. The pistol was designed to hold 17 rounds, but California law said you could only load 10, so you had to buy modified magazines or risk felony charges for having the standard magazine that came with the gun. After this ruling, that California law is unconstitutional. You have the right to own and use the magazine that your firearm was designed to function with. But wait, there's something even more important that most people are going to miss about this ruling. The real power of this decision is not just about these 3 specific restrictions. It is about the legal standard the court reinforced. The court doubled down on the Bruen test. They made it absolutely clear that any firearm regulation in America must pass a historical tradition test. The government cannot just say a law is a good idea. The government cannot just claim public safety. They have to prove, with actual historical evidence, that the type of restriction they want to impose has roots in American legal tradition, specifically around the time the Second Amendment was ratified, or during the Reconstruction era, when the 14th Amendment applied the Bill of Rights to the states. This is a massive deal because it sets the stage for dozens of other gun restrictions to fall in the coming years. Think about assault weapons bans. Think about universal background check mandates on private sales. Think about red flag laws. All of these are now going to be challenged under this same framework. And if the government cannot find a historical analog for them, they are going to be struck down too. Now here is what most people get wrong about this ruling. Some people think this means there are no gun laws anymore. That is absolutely not true. The court was very clear. Laws against violent felons possessing firearms still stand. Laws against bringing guns into actual courthouses, actual prisons, actual secured government buildings, those still stand. The background check system still operates. What changed is that the government can no longer invent new categories of restrictions that have no basis in American history and force them on law-abiding citizens. Let me give you another hypothetical example to make this real. Imagine you are driving through New Jersey on your way to visit family. You have a valid concealed carry permit from your home state. Before this ruling, New Jersey had so many sensitive place restrictions that you practically could not carry anywhere legally, even with a permit. After this ruling, those overbroad and sensitive place designations are unconstitutional. Your right to carry in normal public spaces is protected. Now, you still need to understand reciprocity laws and whether New Jersey honors your specific permit, but the blanket sensitive place bans that made carry practically impossible are gone. This information could literally change before January 2026, depending on how states respond. Some states might try to pass new laws. Some might drag their feet on compliance. Subscribe right now because my next video is going to cover exactly what each major state is doing in response to this ruling, and what you need to do to stay legal in your state. Do not miss that one. Here's another thing I want you to understand. The 3 dissenting justices wrote a very strong dissent. They argued that the majority is being too rigid with the historical test. They said modern problems require modern solutions and that the government should have more flexibility to regulate firearms in ways that the founders could not have imagined. That dissent matters because it tells you that this fight is not over in the political arena. Even though the legal question is settled for now, there will be pressure to change the composition of the court. There will be pressure to pass new federal legislation. There will be attempts to find workarounds. That is exactly why you need to stay informed. That is exactly why channels like this one exist, because the law is not static. It moves, it shifts. And if you're not paying attention, you can go from law-abiding citizen to accidental criminal overnight. So let me bring this all together for you. The Supreme Court, in a historic 6-3 decision, permanently struck down 3 categories of gun restrictions. First, overbroad sensitive place bans that turned entire cities into gun-free zones. Gone. Second, mandatory waiting periods that delayed your right to take possession of a firearm after passing a background check. Gone. Third, state-level bans on standard capacity magazines. Gone. And on top of all that, the court reinforced the Bruin historical tradition test as the only legitimate framework for evaluating any gun law in America, which means more restrictive laws are likely to fall in the near future. This is the most significant expansion of Second Amendment rights in our lifetime. And it happened because the court looked at the Constitution, looked at American history, and said, the right of the people to keep and bear arms means exactly what it says. Look, I spend dozens of hours every single week researching rulings, reading court opinions, and breaking them down so you can understand them in plain English. If this video helped you, if it made you smarter, if it made you safer, then I am asking you for one thing. Subscribe to this channel. Hit the bell icon so you get notified the moment I drop a new video. Share this video with every gun owner you know because they need this information too. We are building a community of informed, responsible, law-abiding gun owners who refuse to be caught off guard. Be part of that community. And one final reminder, everything in this video is for educational purposes only. I am not your lawyer. This is not legal advice tailored to your specific situation. Laws vary by state and they change constantly. Before you make any decisions about purchasing, carrying, or transporting firearms, talk to a qualified attorney in your jurisdiction. Stay informed, stay legal, stay safe. I will see you in the next one.